pledge allegiance
to the flag of the United States of America
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thanks. So the first item on the agenda of action is the election of officers, and I'm going to have Mr. Fricke kind of lead that since he's such an expert at it. So.
All right, as the first agenda item so that we can proceed with this board's actions is to elect the chairman. What I would like to do is, the process that I would like to do is to take an individual motion in consideration. Once we have the motion to elect a specific or to appoint a specific member, we can discuss and figure out, if there's other members that are interested, so that you know what you're doing. But we'll go one at a time, each motion as it's raised, and look for the majority on each one. And then if that fails to gain a majority, then we can go with another one and we'll proceed. So at this point in time, I'd ask for any sort of motion to appoint a chairman to the Planning Commission.
I move we appoint Ron Gilbert as chairman.
Okay, is there a second? I'll second. All right, any discussion on the motion to appoint Ron Gilbert as chairman of the Planning Commission? If there's no discussion, we'll call for all those in favor of appointing Ron Gilbert as chairman of the Milton Planning Commission.
Aye.
Oh, thank you. And all those opposed? Appeared to be a unanimous 6-0 decision. Mr. Gilbert, I will now turn over the meeting to you.
So now we need a vice chair.
Thank you very much.
No, I would have Mr. Gilbert go ahead and proceed with appointing a vice chair.
I think the next is for a vice chair of the Planning Commission. So I'd like to ask for nominations.
I'll nominate Sumit.
I'll second that.
Is there any discussion with regard to Sumit's nomination? Seeing none, I'd like to call for a vote. Those in favor, please signify by saying aye.
Aye.
Opposed? It's unanimous. Congratulations, Sumit.
Yeah.
Okay.
You had your chance to say that.
Yeah. Robin, now we do our call for order.
Yeah.
And typically there's a script that goes along with it.
Right.
I believe that script is actually in the bylaws that I just handed out.
So I apologize.
No, that's okay.
Italicized material 3 or 4 pages in.
Just to go through. Which page is it?
3 or 4 pages in,
3.
5 pages?
Section 5.
Section 5. Oh, I see.
And you just have to watch it because I think it has the wrong time and date. That was, I'm not sure which version this is. If it has the wrong, just as you read, if it may have the wrong.
Okay, well, let me.
We changed to Wednesday.
So I believe this is the section. This is a regular meeting of the City of Milton Planning Commission. Mm-hmm. I am Ronald Gilbert, chair of the commission. This is a 7-member commission appointed by the City of Milton Mayor and City Council, created for the purpose of holding public hearings and making recommendations on rezoning, use permits, concurrent variance applications, comprehensive land use plan and plan map, and other related plans and amendments to the zoning ordinance. Oh, and I'd like to introduce the members of the board. Sumit Shah, Fred Edwards, Kurt Nolte, Zach Middlebrook, and Jan Jacobus. And Marty Locke is absent today. And do I carry on here?
Yeah.
The petitions will be heard in the sequence listed on the posted agenda. I would like to acquaint you with some of the rules and procedures for conducting this meeting. The applicant and all those speaking in support of an application will be allowed a total of 10 minutes to present the petition. The applicant may choose to save some of their time for rebuttal following the presentation by the opposition. The opposition will be allowed a total of 10 minutes to present its position. If time remains, the opposition will be allowed to rebut. Since the burden of proof is upon the applicant will be allowed to make closing remarks, provided time remains with the allotted time. The staff of the Community Development Department will be keeping track of time and will inform you periodically of the remaining time for your presentation. Each speaker must fill out a speaker card before speaking and leave it with a staff member of the Community Development Department. All speakers will identify themselves by name, address, and organization, if applicable, before beginning their presentation. When an opponent of a rezoning action has made, when an opponent of a rezoning action has made within 2 years immediately preceding the filing of the rezoning action being opposed, campaign contributions aggregating more than $250 or more to local government, to a local government official of the local government, which will consider the application. It shall be the duty of the opponent to file a disclosure with the governing authority of the respective local government at least 5 days prior to the Planning Commission meeting. A violation of the relevant state statute constitutes a misdemeanor. Therefore, if you have contributed $250 or more to a council member and have not timely filed a disclosure prior to the Planning Commission meeting, the city attorney strongly suggests that you have someone else speak on your behalf. Each application has been properly filed with the Department of Community Development. Signs have been posted on each site. The matter has been advertised, and the notices have been mailed to property owners affected by this zoning as required by the Milton Zoning Ordinance. The Planning Commission's recommendation will be forwarded to the City of Milton Mayor and City Council for final disposition. The Mayor and City Council hearing will be held approximately 3.5 weeks from this hearing on the third Monday of each month at 6 p.m. in the council chambers. The Community Development Department has reviewed each application in conjunction with various agencies and departments, both internal and external to the city. Staff recommendations, findings, and conclusions are here before us in written form, which has been made available to all petitioners and to the public. Demonstrations of any sort within the chamber is prohibited, so please refrain from any applause, dialogue with the person speaking, or outbursts. Please turn off all cell phones or place them on silent. All remarks will be addressed by the Planning Commission. Please show the same respect to the person speaking that you expect to receive yourself. In addition, the applicant shall not submit material to the Planning Commission during the meeting unless requested to do so by the Commission. All material that you wish to be reviewed by the Commission in consideration of your application should be submitted to the staff of the Community Development Department to be included in the normal distribution of packages to the Commission. Finally, to the applicant, if your petition is deferred in accordance with the Milton Zoning Ordinance, you are required to update or obtain a new sign for reposting. Failure to update or repost will result in further delay. There are no exceptions. And
Okay, so there, so you had call to order. We have no public comment. So now we're going to go on to the approval of action minutes based on the absence of people and new members. We're going to make a motion or decision on the December 18th, 2019 Planning Commission meeting. So,
is there any discussion on the the action minutes as presented to our commission.
I move we accept the council meeting on Wednesday, December 18th.
Is there a second?
Second.
All those in favor, please signify by saying aye.
Aye.
Opposed? It's unanimous, Robin.
Okay, so it would have been the 4-0, right? Or because of the, yeah.
Could you indicate which four affirmatively
which four, yeah.
voted?
Yeah.
Okay, thank you.
Okay.
Yes, thank
We're
you.
friends, the group. Okay.
So just passing on the 29th?
Not yet.
Oh,
Oh, yeah, so now it's January 29th, 2020 Planning Commission meeting, so.
Is there any discussion of the action minutes presented for the Jan 29 meeting?
I move we accept the Planning Commission's action minutes for Wednesday, January 29th, 2020.
Is there a second?
I'll second.
All those in favor?
Aye.
Opposed? Unanimous again.
We're all six
Yeah,
we're all six here.
No.
I wasn't here for that.
Five, okay.
Actually,
I was not here either.
yeah,
Yeah.
So again, 4-0 this
4-0.
time with.
That's right.
yeah.
So as a point of order, I thought in the past that if they were members, that they could still vote on it based on the fact if they reviewed or not.
If you have reviewed the video and can affirmatively state from firsthand experience that the minutes accurately reflect what occurred, that may be acceptable. But what you are stating is that the document presented before you accurately reflects what occurred at that meeting, and unless you were here, that's probably the only way that you could affirmatively state that.
I cannot make that statement.
Okay.
I cannot,
Okay, that's
And
fine.
so
Four.
you can't,
I can't second.
yeah, you can't second, how can he second if?
That would be correct. We should probably clarify.
Let me take it back. Do I hear a second to Fred's motion?
I'll second it.
All those in favor signify by saying aye.
Aye.
4-0-2.
Opposed? It's unanimous again. Those four.
Just clarification, so we have to watch the video, because I know we've had issues with calling in remotely if we're out of town for business. I know we have issues where the phone doesn't sync with the voice. Can we call in, and would that suffice, or do we have to be watching the video?
If you participate by phone,
Okay.
Yeah, I don't think you have to watch simultaneously, yeah, no.
I guess that would probably allow you to
Okay.
affirmatively state that that does reflect what happened.
Perfect.
I mean, that's the point, is you are voting to say that the minutes accurately reflect what occurred at the meeting.
Sure.
Okay.
Makes sense.
So the next item is U 20-01, VC 20-01, 12900 Arnold Mill Road by Ebenezer United Methodist Church for use permit, section 64-1804, to construct a 23,000 square foot activity center on the existing church property for a total of 28,088 square feet on 6.61 acres to request a four-part concurrent variance to 1, delete the 75-foot undisturbed buffer and 10-foot improvement setback adjacent to the north property lines and the property line labeled north 10 degrees 22 minutes 54 seconds east. And number 2, to allow parking in front of a building. Number 3, reduce the required parking. And lastly, to reduce the use area structure setback from 100 feet to 25 feet from any adjoining residential district or AG1 use for single-family dwellings. As I stated here, the applicant is requesting a deferral to March 25th of next month. So staff has met with the applicant and their architect, and they're finalizing a revised site plan that would eliminate 2 concurrent variances, which we see that's a positive. And it wasn't enough time to really be able to fully evaluate it, as well as looking at the architecture a little bit more with the new positioning of the building. So staff is supporting the request for deferral. So Mr. Elkins, the architect, is here in case you have any questions, but if not, if you want to go ahead and if you have any questions for me or whatever you want to do next.
Are there any questions of staff or the architect?
I just had a quick question about, do you have to re-advertise this?
Yes, and there'll be enough time to do it, yes.
There isn't going to be enough time before. How long do you have to advertise before?
So it's 15 days prior to the meeting.
15 days.
Yeah, both for the sign, the public notice, and the newspaper, as well as the notices sent in the mail, yeah. So.
Well, then, is there any discussion, further discussion? I'd accept a motion to defer.
Sure, I make a motion to defer U20-01, BC 20-01 to the next Planning Commission meeting, which is going to be on March 25th, 2020.
Is there a second?
I'll second that.
All those in favor?
Aye.
Okay,
Opposed?
great,
It's
thank you.
unanimous.
Sorry for your inconvenience, but we just wanted to be here. So now we're going to have a training by Mr. Fricke, and let me help him make sure we get everything.
Pick either one of these. I guess the one that fits would be the best one.
Ever. I've been on here since we started. This is never seen this since December 6th. When we became a city. I've never seen any training.
And as that's getting set up, I'll let you know what there's a package of 3 sets of documents, and one set of bylaws, which are the guiding documents specifically for this body, and mostly with procedures we'll go over. I'm not going to go further, but it's good that you all have them, to review them when you get a chance, just to see what the rules are for the body. There's a set here, it's the ethics code. I strongly recommend that you read through that, probably like the first, I think, 8 pages. I mean, not tonight, or not right now. And it's kind of typically going to be some obvious stuff. You know, don't do anything bad. don't do anything that would be a conflict, and that's it. After the first 8 pages, it gets into the penalties and the complaint process, which we'll assume that we won't ever have to go through with. Otherwise, it will become more important that you get involved with the details. And then finally, there's a package here that's got all of the slides that I'm going to present to you tonight. Either follow those, take it home with you, or do with it as you want. I obviously didn't get the date corrected on this. I've previously trained a couple of different bodies, including the Board of Zoning Appeals and several other jurisdictions as well. The goal tonight is to give you a broad overview of many aspects of participation on the Planning Commission, from the substantive issues of what does this body do, to the process of just running a meeting and going forward as a member of an administrative body. Starting with the most relevant thing is, what are the duties of this Planning Commission? I've pulled out sections from the City of Milton Code. The important one there is the first one, which says the commission is charged with upholding the policies of the city comprehensive plan when reviewing rezonings, use permits, concurrent variances, changes to the city zoning ordinance, or text amendments sometimes they're referred to. There's a few other things that may come up. But that's the principal statement of the duties. That's actually in the charter, which sets up this Planning Commission. Below that are a number of sections. Your responsibilities are kind of scattered throughout. As you can see, I think there's 7 or 8 different areas where it makes reference to. Essentially, the Planning Commission holds a public hearing, on the various applications. They're sprinkled throughout, but you can see it refers to preliminary plat approvals, to cell tower permit approvals, to concurrent variances, text amendments, rezonings, those responsibilities. Now, those are all things that'll come before you. You'll be provided with the information. You don't have to go and look for the authority, but just letting you know that the authority comes from the charter and the City of Milton Code to authorize this board and require this board to conduct public hearings before it goes to the mayor and city council. Now, what I like to present to you is when you are making a decision, and these are on zoning decisions, zoning proposals that come before you, when you're voting to approve or deny or approve with conditions or to postpone, these are the considerations set forth both in your bylaws. You'll find them in your bylaws. They're also set forth in the city code. These are the items which you will consider in whether you make a decision to recommend approval or recommend denial, whether it will permit a use that's suitable in view of the use and development of adjacent nearby property. And if you have any question about what any of each one of these means, please let me know, because these are the critical things that you understand what the basis of your decisions can be. So basically, is the proposal suitable given the surrounding uses? Second, whether the zoning proposal will adversely affect the existing use or usability of adjacent or nearby properties. Pretty much the same sort of thing. Is this proposal going to create an adverse impact on the other properties around it or the surrounding community around it? Most importantly, the adjacent properties, but you can look the next layer, the traffic through the whole community, those sort of issues.
When you mention nearby, how?
It's a sliding scale. The further away, the stronger the impact would need to be to actually do it. If it's going to jam up traffic on the entire city streets, just it happens to be that's the way the traffic pattern works out, then it's relevant throughout the whole city. That isn't typically going to be the case. Typically, you're looking at a visual or a sound or a traffic impact at the next intersection up or the very immediate adjacency. So these are not a black or white sort of questions, and you're going to find a lot of these things are how big of an impact, how close. That being said, the next question based on it is, can you come up with a condition that would ameliorate that effect? So just because it could cause an impact, if you can do something to prevent it, if it's a two-story commercial building next to an agricultural property, if you can put landscaping along all of the borders that's 50 feet wide, that would prevent that visual impact. Maybe you consider that you can satisfy both. That would reduce the impact on the adjacent property so that you could satisfy that consideration.
So we have the ability to put condition or recommend conditions such if there's a left turning movement that backs up traffic, we could condition that driveway on a right in, right out.
Absolutely. I have some slides on conditions.
Flexibility versus just saying no, we don't want it.
Absolutely. Your options are approve with conditions, or to recommend approval with conditions, recommend denial, or recommend postponement. So absolutely, always be thinking about whether there's something that can satisfy both the applicant who wants to do something and the neighbors or the rest of the community that would be impacted. Third, whether the property to be affected has a reasonable economic use as currently zoned. This is drawn from basically the litigation requirements that have been established for 40 years, the impact to the property, the value of the property versus the impact to the public. So if the existing zoning that is on the property renders the property virtually economically unusable, then you should consider whether something other than the existing zoning would be appropriate. The more that the property is impacted by the existing zoning, the more you should think about whether you should provide them with recommend approval of some sort of relief. That being said, I will say, just because the new proposal is more economically beneficial than the existing isn't necessarily a ground. They don't have an absolute right to the highest and best use. Now, you should weigh that in the impact compared to the impact on the surrounding community.
So, Paul, are you saying in these that we would make recommendations back to the applicant?
No. When I say recommendation, because you're a recommending body to the city council, mayor and city council, your decisions are not approval or denial. They're actually recommendations of approval and recommendations of approval with conditions, recommendation of denial. Those.
So we're not to recommend that if you put up all these trees and so forth, why?
Right. That's what I'm talking. Speaking of recommendation, I'm speaking of your decision to recommend something to the mayor and city council.
Okay.
Yes. Fourth, whether the proposal will result in a use which cause excessive burdensome use on existing streets, transportation facilities, utilities, and schools. And we're kind of talked a little bit. The impact on the city's infrastructure is something to consider as well. Typically, it's more of a roads issue, I've found, but existing utilities is often the case. I don't know to the extent schools is an impact in the city of Milton. I know it oftentimes is something that is concerned as development outstrips the Board of Education's development. Next, whether the zoning proposal in conformity with the policies and intent of the land use plan. This is something that a lot of people will point to and say, how can you, if the comprehensive plan proposes that the use is in a certain character area and their proposal isn't consistent with that, can you approve that? Well, it's not an absolute bar or barrier in the city of Milton. There's it's not a requirement that it absolutely match up with the comp plan. The comp plan is a snapshot in time as to what the future thought is on what the city will look like 5, 10, 20 years down the line. Things change. One property may develop where it wasn't developed when the comprehensive plan was adopted, may change the thought process. I mean, it's something to consider, and I believe staff includes that sort of information in the report, the comprehensive plan.
Correct. That's very integral into the report is what the comprehensive plan states for that area.
So you'll have that information, and that'll give you an idea of what, at one point, when it was adopted, what the city was thinking at the time. And it is a relevant consideration what the city is planning for the future and whether introducing a totally different element or use into that area would have an impact on the rest of the area and whether that would defeat the intentions or not. Again, it's not a black or white question, but it's a factor that you should consider.
And just to interrupt for a second, we just have received bids for the next CPAC, comprehensive plan project update. It's not an update, it's a full update every 10 years. So that'll be something that the Planning Commission will be very active in, probably starting in the summertime. So it's going to be the last time there was an update was in 2016 and a full revision was done in 2011. So Fred, I think you're the only one left. It was on the original one. So
Yes.
Anyway, so that'll be an important job for y'all.
How does that selection process work? You said we've gotten bids from multiple people?
Right. So it's a procurement process that we do for any large dollar amount. And so a bid was advertised, and it was just closed last Thursday, and we received multiple bids. So now we're going through and evaluating them, and then we'll invite the top 3 or 4 for interviews, and then, make decisions based on various criteria and go from there. So, yep.
All right. Moving on, the next item was kind of mentioned the consideration, which was that if there's been any changing development in the area that would be different from what the comprehensive plan contemplated, then you can take that into consideration. And finally, the city's included a question or a consideration as to whether there would be an environmental impact. So those are the factors that you should be thinking about when you're deciding, I want to recommend approval, I want to recommend denial. Those are the statutory and in your bylaws factors that you should be considering making your decisions based on. And you should be able to articulate. You don't necessarily have to articulate each and every point every time you make that decision, but in your mind, kind of bear in mind whether you can justify to yourself that, after weighing each of these, the final result that you come up with is that recommend approval, recommend denial, recommend approval with conditions. All right. If there are no further questions about the considerations that you'll be applying, all right. I've just pulled a couple things just so you see the actual language. This is, I believe, from your bylaws. Let's see if that's where I did see that. Yeah, here we go. That's Article 4 of your bylaws. And it doesn't really say, but it does, important for you to note the meeting attendance requirements. It says attend 2/3 of all regularly scheduled meetings. It's not an automatic removal, but it, as it says, it warrants removal, and that would have to be action taken by the mayor and city council, I believe. Note, it does indicate it's your duty to share written material received, including emails, related to any of the matters. So if a neighbor or an applicant sends you something that's related to an application, you should consider that as a communication to the council, to the planning commission as a whole. And typically the easiest thing to do is send it to staff, and staff will distribute it. Section 3, no member shall discuss with any applicant any matters pending before the planning commission. I don't know whether you get requests to talk to applicants or not. That is typically something that we certainly ask and impose on the Board of Zoning Appeals, just because they are more of a quasi-judicial body intended to only consider matters in front of them. And that's typically what we look for from this board. And the intent is that you render a decision based on the presentation in the hearing before you.
Well, in the past, we have, in at least I can remember over the years, 3 or 4 times that we went out to a location with the applicant to look at the property, to look at the building. So would that have been a violation?
I would certainly say, and I know the Board of Zoning Appeals has adopted a process whereby their applications include an authorization to allow the members to visit the site. Now the members are asked to do that individually so that there's no question of there being a meeting, and we can talk a little bit about the Open Meetings Act. And there is no problem with visiting the sites individually, and I would suggest that it's not a bad idea at all to physically eye the site. Now, obviously, you can't trespass onto property, And, on a large acreage tract, you may not be able to see what the back of the property looks like. As those come up, I would encourage any sort of group efforts along those lines to occur through the staff and if necessary, through the city attorney's office to consider whether or not it's a good idea if multiple people have to go. But anyway, as those individual items come up, let staff know, and we can help to guide you through those processes. But individually,
In the past,
I think we've only done it maybe 3 times,
Yeah,
and then we would
yes.
go in small groups, so we wouldn't have a
Yeah,
quorum.
we wouldn't have a quorum.
And we obviously had the permission of the property owner, so it was a little
Sure.
bit more informal than how the BZA set it up, but it's not very often
No,
that
we
we've
said
had
about
that,
3
yeah,
times, I
right,
remember.
yeah.
okay. And certainly, probably a very, one might assume it would be the case, but do not render any opinion with regard to a pending application. The point is to be guided by the information that's presented up until the application is heard, and not to come in with a bias. You may have a leaning or a tendency, but there's no reason to establish any basis for challenging a decision by announcing, I'm sure I'm going to be voting in favor of this, and I don't care what the neighbors present. I'm taking an extreme example, but those are the sort of things that can beg to bring a court case if the decision goes against one side or the other. So I would certainly say have an open mind until you've had the public hearing, and make your decision based on those considerations that were presented before. And then it mentions each member to recuse himself in the event of any conflict of interest. That's based on ethics. But bottom line, and I'm going to touch on this so we can just kind of, it's very important, and I do want to hit it here. I've got more. You've got the whole ethics ordinance, and I've got more language later on in this presentation about ethics. But bottom line is, if you own the property, obviously you've got a conflict of interest. Most obvious example. If you own the property next door, you might be able to justifiably say, I can make an unbiased decision, but the appearance of a conflict of interest is so strong, I would say you would need to recuse yourself from that decision. Once you start moving further and further away, I think your ability to provide an unbiased decision in any given case gets stronger and stronger. So if you're one property away, yeah, it may depend on what exactly that property is in between the two of y'all, or what exactly the proposal is. But the bottom line is you should be able to give an unbiased opinion. You should be able to affirmatively state, and if it's close, I will ask you to identify for the record, I have a half interest in a farm that is, quarter of a mile away. I have no problem rendering an unbiased decision on this case, and will do so. If something comes up and it is, you feel like there is an obligation to recuse yourself, what the process would be is to announce. You should not participate in discussions with the board outside of the meeting, or the commission outside of the meeting. You shouldn't provide any input to the staff or anything like that. Once you get to the meeting, when that agenda item is called, announce to the chairman that, Mr. Chairman, I own the property that's right next door. As a result, I'm going to recuse myself, or whatever. I own a 25% interest in the LLC that owns the property. Therefore, I'm going to recuse myself. And then I'd have you come and sit, just sit in the audience. You don't need to leave the room or leave the building. I would suggest that you do not, you do step down from the dais, so there's no suggestion that you're, handing notes or whispering to any members, or whispering quiet comments. just for the appearance of a true recusal and a true non-participation in any aspect of the vote. As soon as the commission makes its recommendation, come on back up and just begin participating again.
Paul, with
Yep.
regard to point number 3 here, which says we should not have any discussion with an applicant about something that's going to be coming to us, how should we handle a situation where a citizen, a concerned citizen, knowing that we're on the planning commission and knowing that something's going to be coming before us, approaches us to discuss that?
Given this item in the bylaws, what I would suggest is that they be directed to staff to provide such that the citizen or the applicant can provide their input to staff either by way of an email or a letter, the staff can encourage them to attend the public hearing and present their comment.
So basically redirect them to staff.
Yeah.
Okay.
And they do have the, I believe, I'm sure they have the ability to reach their council member, representative. So they're not shut out not shut out completely by any stretch, but you are guided by these bylaws to not engage them in substantive discussion of the case. In terms of the process, and I've pulled this straight out of your bylaws, you'll find this, but this is the kind of the flow of a hearing on an application that's presented to you. And you even read most of it as part of your opening statement, so the public hears, but basically the chairman identifies it, staff presents their information and background to the commission. Chair will call the applicant to come up. Chair will call for public comment. And let me ask, this calls for 10 minutes of public comment in general. Do you have I will say we need to provide for 10 minutes in favor and 10 minutes against. Equal time, a minimum of 10 minutes. And I didn't look at this
I think that's typically we have the applicant and anybody in favor of do 10 minutes and then any opposition. And then obviously if it takes longer, the commission's been really good about giving equal time.
Right. And
that may be something we need to look at.
I think we need to evaluate this because as I'm reading through it and going down the list, it appears that we may need to we'll make sure. The key is the zoning procedures law, the state zoning procedures law requires every jurisdiction for its valid public hearing to provide at least 10 minutes for those in favor and 10 minutes for those opposed. That's not typically a problem. On controversial ones, you may get that much. A lot of times it's the opposed. The applicant will present their 5 to 7 minutes and reserve some time, and then a streamline of opponents will come up. And it is, I think it says staff will keep track of the time. When the 10 minutes runs, the chairman should say, we've reached the 10 minutes. We need to close the public comment. You can leave it at that, or the commission may say, you know what, there's only 2 people left. Let's hear them. If there's 30 people standing up, and then everybody has been repeating themselves for the last 2 or 3 speakers, you may opt not to. But you may have a motion to extend public comment.
Motion to do that?
Yes, and it would be a motion to extend public comment for an additional 2, 3, 5, 15, whatever minutes, and it would be each side. If you extend the time on one side, you need to extend the time on each side. State law requires that. Eventually, I think the applicant will get a chance to provide closing statement rebuttal, and then the chair may close the public meeting. That is a closure of people voluntarily presenting information to the Planning Commission. You may still call upon staff, call upon the applicant, call upon an opponent, a neighbor, someone who's specifically impacted. Say, how much can you see of the house that's there. You know, how far away is your barn from the property line? You know, things of that nature. You can direct those questions, as many as you want. We'll say, bring people up to the podium to answer your questions. Don't call them out to the back. Just the microphone will pick it up, and staff can present the minutes based on that, if they can go back and watch the video and hear what they're saying. So go ahead and call them up. Mr. So-and-so, can you come up for a minute? I had a question for you. Once that's done, the process is to call for a motion. So a lot of times there's a lot of discussion before the motion comes up. Theoretically, the process is first to get a motion that you can talk about. I know, a little bit of comment is okay, but it's preferable if you don't go 15, 20 minutes of discussion back and forth without really having anything technically on the table when your rules call for a motion. So just go ahead and, motion to approve for discussion. Our motion to recommend approval with conditions for discussion, and a second for discussion. Obviously, no committee, it can be withdrawn, it can be amended, it can be voted down. It's just to theoretically get the process that you're talking about a specific proposal rather than talking about the application in general. Were you getting ready to say something? Okay. You get the second, have your discussion. A lot of times, you may have heard the term friendly amendment. I will tell you, there isn't necessarily such a thing as a friendly amendment. There's either an amendment or there's not an amendment. What people think is, if I just ask you, will you change it, we just kind of skip the step of withdrawing and restating, or going through the process of an amendment with a motion and a second and discussion of the amendment and then voting on the amendment. What you should do is, if you've gone through and someone came up with a list of 6 conditions: motion to approve, subject to the site plan with landscaping on the 2 sides and a maximum height of 30 feet. So there's 3 conditions. You discuss it and you think about it, and someone says, I think a couple extra conditions would be beneficial. There's 2 ways you can go about it. You can technically have the person that made the motion withdraw their motion, and then someone can restate the motion with all 5 conditions, or you can say, I move to amend the motion to add these additional 2 conditions. To me, that would be the way that I would suggest doing it. And then you vote on adding those 2. Once you've done that, then you can vote on the main motion with all 5 then in it. So vote on the main motion as amended. So I would propose doing it. And sometimes someone might make a motion. For example, I move to do it without conditions. Someone can make a motion to amend, rather than voting against approval. You can say, first try to amend the motion for approval with this condition. So to add a condition to the motion. So that would be one way if you like that. Or maybe you think the conditions are too harsh. Rather than voting against it, you want approval, but you think one of the conditions is a little harsh, then you can move to amend condition 4 to make it 10 feet instead of 20 feet, or whatever the case may be. And then you can vote on that, and then you vote on the main motion, whether it was amended or it stayed because the amendment failed. Any questions about the process of going through that? And I may have some more in there. I'm kind of hitting it as it goes through the process of a meeting here. It makes some sense.
I just skipped over, because I will like to, you're going to discuss more about conditions, because I think conditions can get a little.
I'm going to go.
Yeah, so
conditions are a very important part of what y'all do, and I do have a section in here. Just for your information, this is pulled off of the code. That is theoretically the flow chart of an application from a submission all the way to the city council vote. And you see you're actually 2/3 of the way down. There's a lot that's happened. There's been several meetings that have taken place with staff and with the community before it gets to you. So hopefully a lot of stuff may have been worked out so that if there is some agreement and some conditions that need to be put in place, that they will have been potentially worked out before it gets to you, and the applicant is aware of what the community would like. And you should have, that did make it into the package, although it's pretty small. And any of this stuff, if you want to get with me afterwards or let me know, I can get you the electronic version of this as well. But all right, let's talk about conditions. It's probably pretty rare on, at least on a rezoning, that a zoning goes through without conditions. To just say baldly, you have commercial property now. If you go from agricultural to now it's commercial, do commercial however you want. I doubt that will probably ever happen. It may, I don't know, but chances are there's at least some condition, and at least one of those typical conditions is going to be something that's tied to a proposed site plan. It's one thing to say, I want to do commercial. You may say, I don't want to give you free rein. If someone else comes and says, I'm doing this, I'm like, okay, that sounds good, but I'm going to hold you to that. So the key is to make sure that there are conditions that are legal and practical. From a legal perspective, a condition is imposed in order to, I think the phrase is, ameliorate the deleterious effects of the zoning proposal that's being approved. Basically, that means, how do I take the bad impact and lessen that? So again, if you've got a super tall building, put up some tall landscaping that prevents the site imposition on the neighbors. If it's a smell that may be created, require them to install some sort of filter system with respect to the process, mechanical process, manufacturing processes they're going to be putting in. If it's left turn issues, creating a traffic hazard, make it require right in, right out. Those sort of things are absolutely within your power. They're absolutely legal, and they make sense. Again, keep in mind, the point of imposing a condition is supposed to be preventing the harm to the neighbors. It's not to be imposing, I want to see it this way. I like it better this way. I feel like it would make sense to do this. Now, your thought may be I want to do this in order to protect the aesthetics of the community. The aesthetics of the community is a factor. If you've got an eyesore, nice, oof, nice. It may be justified in preventing an eyesore from being built on property. So requiring aesthetics is a justifiable condition to prevent potential financial harm to neighboring property owners. So it is something you can, but it's just to keep in the back of your mind. It's not to allow the city to necessarily say exactly what's to be done. It's to protect the rest of the citizens from the harm that may arise out of allowing this change in the use of the property.
Paul?
Yeah.
In the past, staff, as they go through and review this, bottom line, they say they will accept it with conditions, and then they list the conditions. So you're saying that still is the proper way?
Absolutely.
We would be adding to or taking away.
Staff is presenting you staff's recommendation. Just like you recommend to the
Right.
city, mayor and city council, staff is making a recommendation to you. Now, they are going to do probably a more detailed analysis. They have a background, they've been doing this, they know the city back and forth, obviously. They use the code all the time. They know what the planning, the comprehensive plan is in the past and coming forward. They will be able to provide you with their professional experience in what conditions make sense from what they can see. You can accept any of them. You can use any of them. You can use none of them. You can come up with new ones. Maybe staff hadn't heard from several of the neighbors, and you find out that there's an old dry run that has been there for years, and the deer walk it every spring. We don't want that to go away. You may decide you want a condition to protect that. So you're not bound by what staff presents.
Understand.
I would absolutely pay attention to what they present, and I have no doubt that y'all do. But so you can recommend recommendations as presented by staff is often. You don't have to read out every one in your motion because staff will, I believe, read all of their recommended conditions as part of their presentation. You can recommend staff conditions 1, 2, 3, and 6, and you maybe leave several of them out. Recommend approval with staff conditions plus the following 3 conditions. Any way you want to do it, you can do that.
Okay.
So that's the legal impact. They should bear a relationship between the likely impact of the zoning and lessening that burden to the neighbors, so the people in the area. As a practical matter, conditions should be reasonably enforceable. The more detailed you can be in terms of what you want them to do is going to be easier for a code enforcement officer to go out and say, you are or you aren't doing that. If you get to say, it should look like the surrounding area, that's pretty vague. And, a code enforcement officer can go out and provide an opinion. Does it look like the rest of the surrounding area? I don't know. Where does the surrounding area start and end? What does look like mean? That'll be hard to enforce. Even if the code enforcement officer has his opinion, when you go into municipal court and try to get the judge to agree, it's a quasi-criminal action, and you get they get the benefit of a lot of the doubt in terms of whether or not they violated that. So if you want to say, shall, use, if you got boiled down to it, you can list the colors. There are code numbers for the colors that they can use. That may be getting a little too detailed, but try to be as clear as possible, and your substantially similar to is better than like. So the more affirmative and the stronger you can make the requirement, the easier it is for a code enforcement officer and then anyone pursuing any violation to act on it. And they should be clear. If you say the property line, you might want to say the northern property line, or the border between parcel, the border with parcel, and give a tax ID number. Again, you want someone to be able to go out and it to be obvious what the zoning condition requires and whether or not they're complying with it or not. Staff will do a good job of presenting you with enforceable conditions. And if you have any questions, you can turn to staff. And if I'm present, I'll be happy to help you work on them. If you have thoughts on what you might want to do ahead of a meeting, that you've looked at it and you see a condition, you're kind of mulling around in your head when the meeting comes up, you haven't set on it, but it's something you're thinking about, feel free to either talk to staff ahead of time and say, hey, I was thinking about doing this. What do you think about this language? Or to myself, we can come up with some language that we could recommend makes sense, is enforceable, is specific enough without being too detailed. We can work through things like that. That saves time trying to make it up on the fly. That being said, it's going to happen. Don't worry about it. Don't stop yourself from trying to put in what you think is appropriate to protect the surrounding community. I'll put this in here as well. Trying to duplicate rules in the zoning ordinance or other regulations. So if you say, applicant shall comply with the city's noise ordinance as a zoning condition, the ordinance is in place. They have to comply. There's no real point in adding in that requirement. If, similar, the property owner shall remain, 75 feet, no impervious surface 75 feet from the creek, or that's already the rule, so you don't need to impose that on top, as a zoning condition, on top of the existing requirements. That is my discussion of conditions, but they're really important, so I want to make sure if you've got any questions, I covered everything that you may have. Okay, great. You will at times see concurrent variances. There is a difference between a condition and a variance. A lot, and I think we're working with staff to get that separated out. I know in the past, sometimes variances snuck into the conditions. Condition is to protect the neighbors from the harm that might be incurred as to the change in the zoning. A variance is a situation where the applicant property owner gets relief from the requirements of the code. So one is giving relief to the property, to the neighbors. Conditions are relief to the neighbors, imposed extra burden on the property owner, applicant. Variance is relief to the property owner, applicant. They have to do less than they otherwise would have to do. And there are situations where that may be appropriate. This is a list of, if they come before you, what you should consider in terms of considerations. I will point out that it says and it's highlighted in red there. There are 4 situations where a variance is appropriate, but all 4 theoretically have to be in existence in order to be granted a variance. Not offend the spirit and intent of the zoning ordinance. That's kind of up to your interpretation of what is the spirit and intent of the zoning ordinance. If it's, the zoning ordinance is to regulate activity. It says we get to do whatever we want. Our variance to allow us to do whatever we want, whenever we want, with no restrictions. Well, that's not really the spirit and intent of the zoning ordinance. Obviously, that's an extreme example, and it's never going to be that easy. That's really not what these turn on. It's the second one and the third one. Well, the third and fourth are kind of the same. Third and fourth, I'm sorry, they're not. Those 2 are not the same. The second one is the property is specifically, that property is subject to special situations, whether it's through topography, it's got really steep areas, so we have to move all of the development up to the front. Or it's got 3 streams, and the only place where any development can be is in this one little corner, but it's too close to the front property line. Those sort of issues which make it special, and that these rules, the city zoning ordinance provides rules that are applicable through the whole city. Every property has to comply with those. Well, there may be some certain situations where, hey, the zoning ordinance can't contemplate every single situation and provide for it in a citywide code. So what they do is they allow you to get a variance. So you come in, you show that I've got a special situation on my property, not just because I want it. I have a special situation, and the code should be applied differently, in my case, due to my special situation. Size, shape, topography. And also, there's a note that it's not created, condition is not created by the applicant. So if someone comes in and they divided their property into 3 really long, narrow lots, and then they come in and say, hey, I've got a really long, narrow lot, and it's hard for me to build within that little skinny building area. Like, well, you can look at it and say, I know that's a hardship, but you created that hardship, so, maybe you're not entitled to that variance.
That comes up many times.
It does?
It's hard to decide, is it or isn't it a hardship?
And that is always the tough question. What is a hardship? And I always point to pools. Those typically go to the Board of Zoning Appeals, so you're not going to get just a standalone variance. You're only going to get concurrent variances. So someone comes in and say, I want to do a subdivision and I want to have 30-foot tall houses rather than 25-foot tall houses, and they come up with a reason for why, whatever that may be. I don't know. The lot slopes, and it just makes sense to put them on risers, so you need that extra 5 feet to, have a full-size level story on each of them. I don't know. There may be some situation. But I always put it pools is like, someone comes in and says, I need a variance because I can't fit my pool. Like, well, is that really a hardship?
Yeah, right.
I have seen where people actually take the time to present, there's every house in my neighborhood has a pool. If I don't have a pool, then I'm never going to be able to sell my house. Maybe they've presented that with sufficient evidence. I just throw that out. Anyway, that's a personal
My
thing.
favorite was it's been a long time, probably 10 years ago. There was a house that wanted variance to a stream. It's around a lake, surrounding a lake, and there's a buffer to the lake. And so basically, they wanted to tear down the existing house, build a new house, and then also have an indoor pool that would go out to the outside and meander down to the bottom. And so the applicant brought pictures of their kids at Disney World and with smiles and saying, one of their reasoning was, I have to, you're not willing to make you're going to make my kids unhappy if we don't get this new pool. So it was like.
Yeah. So anyway,
Anyway.
I will
That
say.
didn't come, you didn't get it to us.
What's that? No, it went to the
Yeah, you
BZA.
got that and stuff.
Anyway, that is supposed to, there is supposed to be a hardship. There is supposed to be a reason why application of the zoning ordinance creates a special burden on these people. Not just a burden, but a special burden on this particular property and this particular applicant due to an unusual situation with that property. Not just I'd really like to do that, and those rules are in my way. If I could just get those rules out of my way, I would be good. That's not supposed to be the way it does. Anyway, that's up to you when those come before you, but these are the factors you should be weighing when you consider whether or not a variance should be granted. And you can recommend approval with or without the variance. You can recommend approval without the requested variance. You can recommend approval with only so much of a requested variance. If they want a 50-foot buffer reduced to 25, you can say a 50-foot buffer reduced to 35. You can make those recommendations. Any difference?
Are these considerations unique to Milton, or is it
No.
almost the exact same?
Well,
No,
they're-
these are very unique.
I wouldn't say they're unique. I mean, the general concept of
Yeah.
4 considerations is, and basically weighing the spirit and intent, extraordinary and exceptional situations, substantial detriment to the public good, and public health, safety, and welfare secured. Those concepts are completely out there. And then there's kind of a split between whether they say or whether they say you must meet all of them or you must meet at least one of them.
Right. There's other
And
jurisdictions,
there
yeah.
are both jurisdictions. This is the strongest, the use of the word and requiring you to meet all of 4 of the considerations is the strongest hurdle for an applicant to meet that's out there. So bear that in mind when you consider that.
I mean, originally when we became a city, we adopted Fulton counties, and it was these very similar, but it was or instead of and some jurisdictions have or, not and.
And some and there are variations. Some will say you must meet 2. You must meet at least two or 3. The spirit and intent of the zoning ordinance. If you only have to meet one of them, you can almost always at least give lip service to the fact that they meet the spirit and intent. One of the keys that it comes not causing detriment to the public good and surrounding properties. That's the situation where I'm going to give you a variance to let you build up to the property line. Well, the next door neighbor is going to probably have an issue with letting someone build up to their property line. And that's where you have to look at, well, is there a stream and then a utility easement and then another stream before you get to the neighboring property owner's house? Maybe that variance isn't so bad, but you got to look at each situation. And I will say for variances, look at each situation, look at whether or not it makes sense, whether it meets all these criteria, and then make a decision. And again, your conditions can apply equally to variances as they are to the main zoning situation.
Paul, I was just thinking about too, if you could speak to, I know many times people talk about it sets a precedence.
Okay.
So maybe if you can address that
I am aware that is a thing. Yeah, you've heard me use the term each situation is specific to that particular case. In Georgia, as a matter of law, property is considered unique. There's virtually no 2 pieces of property that are identical, whether it's the slope, whether it's the distance from a stream, whether it's the relative distance from a road, whether it's next to agricultural or commercial property, whether it's got a certain type of soil. There are so many factors about an individual parcel of property that there's language to suggest that property is unique. Starting from the outset that your decisions are not going to establish a precedent just because you made the decision. That being said, your goal is to be consistent. So to the extent you are making decisions that are in all relevant aspects the same, you should be consistent. If someone presents to you a 5-acre tract, on a feeder road that is not with no water and a completely flat parcel, one applicant asks to do residential, another one comes in with, if you didn't know any better and you just looked at the plat and all the details that are contained on the plat about the property, and if it didn't have a different address on it, you wouldn't know the difference between the two, then you should think long and hard about whether or not you're treating the 2 property owners equally. And it's a question of essentially an equal protection question, whether under the Constitution you are treating property owners equally given the facts. We will argue up and down that property is unique and there was something about that one property that was different from the other property. That being said, if there's no reason to treat them differently, you really should be treating anyone the same if they're under the same general relevant, specifically relevant factors. So you're not bound by any prior decision. I couldn't define what the situation would be that you're bound by, because like, okay, if someone comes in with a 5.79 acre parcel of property that was zoned Ag 1 and wants to become R3, they're going to present 50 lots, then you must approve it, because that's what happened in the other case. If, chances are you're not going to get exactly the same thing coming before you. But if it's close, no, you're not bound by precedent, but you should be consistent and make every effort to treat everybody equally. But again, weigh each case in front of you with an eye towards what is appropriate in this case. What are the neighbors next to it, and what is this person asking for? All right. Now, we've kicked through a lot of stuff already, so I think we're gonna go through this stuff. Votes require a majority of the members. This is from your bylaws. Tie votes means a denial. If there's a tie vote and it does result in a denial, you'll need to make a motion to come up with another option. A denial of an approval doesn't mean you immediately have to go to a denial of a recommendation or to a motion for denial. You can go for a motion to recommend approval with conditions. I mean, you can go straight to denial, but you don't have to. But you do need to make a new motion. If it's on the agenda, you have to take some action. That action would be approval, recommend approval conditional, recommend denial, recommend deferral. So if you made 3 attempts to make a motion to approve with conditions, you made a motion to approve with different conditions, made a motion to recommend denial, those keep tying or whatever the case may be, and you can't get a motion, you need to actually recommend deferral, make a motion to defer the case. But I would say, hopefully that's a last resort, and probably only if you're deadlocked on a 3-3, because otherwise, hopefully you would be able to come up with, if 3 people are against, or 4 people are against something, one would theoretically assume that they would be in favor of the opposite end. That would be a majority to come up with an actual recommendation. Note, if the applicant isn't present when their agenda item is called, the first thing to do would be to make a motion to move the item to the end of the agenda, move second vote, finish the rest of the agenda. If the applicant still is not there, then it says automatic deferral. What I would suggest is you go ahead and make a motion to defer pursuant to this requirement that it be deferred to the next available meeting. Staff can tell you if they have time. There should be time to advertise and have the public hearing on the next agenda, but staff will let you know if there's any issue with that. All right. Any questions about voting?
Robin, have we had situations where there hasn't been the applicant here?
The applicant hasn't, it hasn't been any time recently. I think people are pretty good.
No, yeah, but
I can say that the
seems
BZA
we
had.
went ahead and that's why I brought the question. I mean, you answered the question.
Yeah.
Was that we went ahead and
Deferred it, yeah.
deferred it.
Yeah,
I mean,
that is.
They were late. I think we pretty much have done that. I don't think you've ever just ultimately denied them because they weren't here.
We weren't here. No. Okay. Good.
For example, it doesn't give you the authority to go ahead and approve it. It says it shall be deferred. Mm-hmm. I mean, some people say, "Oh, this one's so easy. Let's just recommend approval." And it says that you should have to automatically defer to the next meeting. We went over motions. I will say for this body, as I said, the language should be, I move the Planning Commission recommend X, approval, denial, whatever, of the application number. If there's, additional language to rezone from A1 to R2 with 3 variances, or, with the following conditions, whatever. But the language should be to recommend approval or recommend denial. Sometimes people say, Yeah, I move that we accept the application. Like, first of all, you're not the body that makes the final decision on that. And it's not accepting, it's already, the application's been accepted. Now you're making a vote on whether you approve it would be approval or denial. So just a pet peeve of mine is recommend approval, recommend denial, recommend approval with the following conditions. Yeah, there's that motion or remark about consistency. Quick comments about motions. I say rather than can I have a motion to approve, if the chair says I'm looking for a motion to approve and someone says so moved, I think everybody knows maybe what it's meant, but it's better if someone just says I make a motion to approve such and such. I make a motion to adjourn. I make a motion to open the public hearing. Whatever the case may be, it's clearer that way if the actual language is stated. If you're making a motion to deny an application, sometimes it's better to give something of an explanation. I don't believe I believe it's going to cause harm to the neighbors that we can't get rid of. It's going to be overly burdensome on our road system. You're not absolutely required, but it gives some justification. And from what from what was presented, it doesn't appear that it meets the criteria. It's just language that's it's worth including. If you have thought about it ahead of time and you think you may have a complicated, as I mentioned, a complicated motion, or you're thinking, I want to approve, but I don't want the variances, but I want a condition on the second variance, the concurrent variance that's included. I want to give it to them, but I want to be. If you have any questions, talk to staff, talk to myself. We can make sure that the motion is worded correctly and give you kind of an outline or the language that you might consider if that's the way you feel like going after you've had the public hearing. As things are going along, you may hear, a lot of technical data that you want to include, and you're welcome to include all of that. Just take your time. It's better to get that if the applicant has traffic data, or something, I don't know what it may be, but if there's technical specs that you want to require them to comply with, take the time to get it and either read it or include it, a copy of it in the record, and say, with a condition that the applicant include the technical specs on their equipment as stated in, read the title of whatever it is, which is in the record. Take your time to go ahead and get that, rather than saying, and the information that the applicant presented, if you don't have it in front of you, if it's not going to go into the file, just be as clear and black and white and detailed as you can, so that 5 years down the line, 10 years down the line, when none of you all are on the board commission anymore, and I'm gone, and Robin will still be here. What are we talking?
I'll retire.
Yeah. So Robin will have the institutional knowledge, but if there's no one around down the line to remember which study were they talking about when they wanted to? Because there were 3 studies, and the neighbors presented one, and take your time to put it together, put your recommendation together carefully, and it'll be much easier in the future. Like I said, if you know that you're going to have a somewhat complex motion, go ahead and work on drafting it out ahead of time. We talked about conditions. For minutes, this is. Let me just explain. I don't. For those of you who haven't been on a commission before, in Georgia, what happened at this board officially is based on the minutes. Theoretically, if it isn't in the minutes, it didn't happen. Now these days there's video, and that gets. When we take a case to court and the record, if there's a challenge and appeal, the video gets sent to the court and it's part of the record. But legally, so far, the law still says the minutes are what constitute the official record of the agency. So when staff sends you the minutes, look through the minutes, see if they capture everything. Who made the second? Who made a comment or didn't make a comment? If there was a comment that you made that you intended to be in the record and you remember what was said, or you want to go back to the video and you want to include it, make a note of that. And when it comes, you can either advise staff, send an email to staff individually and say, hey, I think in V120, I made the second as opposed to so-and-so. Send that to them. Staff can either revise them and send them around to you again, or bring it to the meeting when the agenda item comes up to approve the minutes. If there's any changes, what you can do is I make a motion to approve the minutes subject to the following change. On page 4, show that Mr. Middlebrooks made the second rather than Mr. Nolte, or whatever the change may be, or reflect that the applicant commented that he was willing to do 10 feet instead of 5 feet, if you remember that and it wasn't included. Whatever it may be, go ahead and review them ahead of time. If you don't have any changes, I think the language should be, and I'm assuming that they get forwarded by email ahead of time. Is that the typical process? Yeah. So the language would be, I make a motion to approve the minutes as presented by staff. Theoretically, you say pursuant to the email on February 22nd or whatever. That would be the best idea. So someone could go back and confirm that what is in the official record of the minutes matches up with the motion says, and they can look at an email from February 22nd to say that was what I was looking at when I approved it, and it matches what is in the official record afterwards. If you have any changes, again, make a motion we approve as presented with the following changes on page 2. Do whatever. Yeah.
So I have a quick question on signing off on the motion. I mean, on the minutes. So right now we have the procedure where the chair, I guess, is it the chair of that meeting, or is it the chair who's currently the chair now?
Right. So we have a situation. I was just thinking about that earlier. So we have a set of minutes from
December.
I would ask that
the chair is no longer on the commission, and
then we get the current chair. I mean, it's fine. The chair of the meeting that approved them would be.
So, for instance, Ron's the chair, but he wasn't at the last meeting. So, is it okay for him to go ahead and sign the meeting for February or for January because there was no minute?
Let me take a look at the Open Meetings Act just to see if there's any specific statutory requirement on that. I'm not aware of one, but because there is an Open Meetings Act that covers a lot of these requirements, let me take that offline and
the last couple of meetings a little.
It's a good question.
Yeah. No, that's why, because again, December's meeting, that chair is no longer on.
Right.
And then I ran as pro tem last meeting.
Right. And now we got a third in a row. Yeah.
Just trying to figure out who would sign off on these minutes.
Yeah.
Ron,
I'll take a
you're
look
not
at
allowed to be absent anymore.
Right. We'll make sure we get that.
Okay.
Yeah. All right. And as it says, the minutes, it says they must reflect what actually transpired, good, bad, or ugly. If there's a heated debate, they don't have to be. You don't have to use a lot of adjectives about describing how the discussion looked and the tenor of the terms, all what was said and what wasn't said. But if someone said something that that would rather either the city or the applicant would rather not be part of the public record, if it was said,
So just to clarify, my minutes now are action minutes. So like you mentioned, that we have the video, we have audio recording of it. So I don't go into a lot of detail other than what the motion was and who made it and all that. So it's pretty straightforward.
And as long as the minutes reflect the speakers, most importantly is who voted on what. Who's present and who voted on what.
Right.
And that's like an
Right.
absolute requirement. That has to be ready within a couple of days. It should reflect speakers, public speakers. They should reflect at least the general nature of the comment, opposed, against, worried about traffic or something like that. Because it's the official record, including something. We can talk about how we do it. What level of detail that goes into. It doesn't have to be verbatim minutes, obviously, but if it just lists who spoke, that maybe we may need to include a little
They
bit.
have to revisit that.
Yeah.
Because that's how it's been since we've had video
Okay.
now. In the very beginning, we had extra staff to be a secretary, and
Yeah.
then it was almost verbatim minutes. And, then that went away, and then I had more detailed minutes. But then once we had the video, we went to action minutes that are pretty minimum, so.
Get back to me, we'll talk about the
Yeah.
minimum requirements of the Open Meetings Act and then what makes sense
Okay.
and what staff has the capability of actually putting out month after month after month. Let me go back to, if you do propose to make a change, you cannot change what you actually said. If the minutes incorrectly reflect what you said or how you voted, if the vote reflects that it was 3-2 or 4-3 in favor of the motion with Mr. Jacobus, Mr. Middlebrooks, and Mr. Gilbert opposed, and you use it, no, I voted in favor of that. You can go back and look at the minutes. That's something that you can change if you really did vote in favor of it, but the minutes reflect that you voted against. Correct that, absolutely. And please do correct those things, because we want the minutes to be accurate as much as anybody else does. But what you can't do is vote in favor of something and then say, I voted against it, change the minutes to reflect that. And, when you see, okay, there was enough votes, I don't want to be on record as having been in favor of something. You can't change what you actually did, but you can change the minutes to reflect accurately what you did. Yep.
So I have a question. So like right now, Robin, I guess in terms of when you prepare the action minutes, are you reviewing the last meeting's video?
So what I do is I take notes, and then if there's a question about my notes, then I'll go back and review it. I don't sit through the whole and review the entire thing. It's only when I have a question about who said what or what was the motion, who seconded
Who may
it.
have made the
Right.
motion, who seconded the motion?
Right, yeah. So, and that would be something I would ask maybe from now on. It's to raise your hands. Because I know it's hard to hear sometimes, and just making it very obvious who's voting which way instead of saying yay. But it would be helpful to raise your hand one way or the other. So, for me to be able to accurately.
Let me add to the ease of staff, if the chair would like to say seconded by Mr. Nolte or whatever.
Right.
Because
yeah,
sometimes you
that's
get like
helpful.
3 people, and as long as it was seconded, no problem. It's not going to be legally deficient. It just makes it clear so that the minutes match what the chairman announces, and it's just easier that way. All right.
Okay.
Meeting efficiency. These types of meetings, and I have not, and with new members, this may, be a chance where the old way may not be the new way going forward. But this is technically not designed to be an open discussion back and forth with the applicant. A lot of boards and commissions will want to do that, and I'm not saying you need to be rude or dismissive of people, but this is your meeting where you're getting information from the public and the applicant to help you make a decision. They're given a structure whereby they present to you, then the supporters present, the opponents present, and you make your decision. Now, you're entitled to engage them in questions. It will be easier on you if you keep to that structure as best possible, because once you open the gates to answering one person's call from the audience or asking another person out in the audience, well, then someone else can say, hey, but what about this? What about this? If you can keep it to the structure of, you know what, you present, and then we'll ask any questions we have them come up so that that's the only person you're talking to. Mr. So-and-so, what is your question? Miss So-and-so, can you tell me how this would work? They answer, and you say, thank you, and they can go sit down. And they only answer that question. That's not their license to go off on a 5-minute tangent of what they wanted to say but didn't get a chance after they heard something else. It should be designed to respond to your specific question and help you to make your decision based on what you feel like you need to know. It is undoubtedly going to happen. As the chairman, you have control to say, excuse me, we will hear from everyone in their time according to our rules. If we have any questions, we will ask questions after the public hearing portion has closed. If you can keep control of the meeting in that sense, then it will be much easier for you. On those tough ones, you may have to be especially noteworthy of those procedures. But if you keep to those procedures, even on the nights when there's only 2 people here, it may seem a little unusual to say, I'll get back to you in just a minute, or will you come up and answer some questions if there's only one person here? But if you continue to follow those simple procedures, can you come up and let me ask you some questions? That'll allow you to get into the habit of doing it. It'll feel natural to do it. It'll feel comfortable cutting someone off and saying, I will get back to you. Just let us go through our procedures, and then we'll get through everything. That'll help you to say, we gave you 10 minutes. Your 10 minutes are up, and I'm sorry, we need to move on to vote. I'll ask you questions if I have any more questions. If you stick to it on the easy ones, it'll make the harder ones. You'll have the ability and the confidence to stand firm going forward. With respect to your motion and discussion process, there's going to be some that are tough. And like I said, ideally you get initial motion on the table to get something to talk about. I don't like this motion. I do like this motion, as opposed to, I'm not sure about whether we should do this, that, or the other thing on this application, and we don't know whether we're leaning towards approval or denial. That's fine, but if you got something on the table, you're supposedly talking about the motion, whether it's to approve or deny or recommend approval with conditions, whatever. Certainly, you will find who likes to make the motions, who likes to really dig into the details, whether you just want to ask a lot of questions or not. That'll be something that the commission will kind of work out its own kind of flavor for how it's going to run its meeting. But just remember that you don't have to be unanimous. Each individual may have a particular interest. Say, keep it polite, keep it efficient, keep it professional, and you should do well. Try not to, if you feel like the debate has been going on along, we don't have this now, but there's sometimes called call the question. That's an ask to end debate. Say, okay, I made my motion to approve with these conditions. Let's vote on this. We've talked back and forth whether or not these conditions are good or bad. If you want to make an amendment, make an amendment. If you want to vote on it, let's vote on it. But let's, stop talking. You have the right to talk as long as you want. At some point in time, it may be and the chairman, you have the authority to effectively say, I believe we've reached the end of the discussion. I'm going to call for a vote. And you can kind of play it by ear. If someone says, no, I haven't been heard yet. Mr. Nolte's been talking for 20 minutes and I haven't got a chance to say anything. You can play that by ear, but try to tease out all of the information that's necessary, but not go too incredibly long. As I said, there is a chance to ask staff questions. There's a chance to ask, if I'm at the meeting, you can ask city attorney meetings, you can ask the applicant or the public questions to help you to make your decision. It should be to get information from them. It's not a chance to debate them. It's not a chance to say, so, did you have anything else you wanted to say? You know, if one person, you know, thinks, I want the opponent to have more time, it's like, so was there anything else you want to say? But it also, theoretically, if technically they're out of time, you know, and it was like a point that you really, you know, kind of, I don't know, you had a sense of what it is, like you can ask them, did you feel like the property was too close? You know, if you know what the point was and you know that you need to have that information, you can ask them, is your house, you know, close to their property? Is that a problem for you? You know, that's a fair, you know, reason to call someone up. You know, don't make it a debate. Don't try to show that the developer was lying. Don't try to prove that the neighbors over-exaggerated something, but clarify it. You don't want to call someone a liar, you know, in front of the whole commission. But if the information is different than you understand it, you can certainly clarify and make sure that the record is clear. Public's not supposed to be asking you questions. Again, if you keep consistent with the, you know, and a lot of times people staff like, well, what's the next step here? First of all, staff, staff can, you can always pawn stuff off on staff of the city attorney, or talk to the city manager if you have issues. You're running the meeting. You're asking the questions. If they don't know, there's going to be some easy questions to answer, and you're going to have a tendency to do that. And it's fine. But the more questions you answer, the more you engage the public outside of the standard procedures, the harder it's going to be to do it when you don't want to. As soon as you start answering questions and listening to calls from the audience, you're going to have a hard time putting it back in the box. You're welcome to, when you're having a discussion on the motions, go ahead and ask, when you said that you were thinking that 30 feet was enough, did you factor into the equation, how far away the stream was from that actual property line? You can ask questions of each other, but again, act professionally with each other. You can show the public to act professionally amongst themselves and towards you. Don't get into. I have no reason to think this is going to be an issue with you. I've seen no indication that you would be the type that would be trying to show up one another. I mean, you're all working towards the same goal, is coming up with a fair recommendation that takes into account the property owner's right to do what they want with the public's right not to be harmed by what their neighbor may be doing. All right, we're going to kick into a couple, and I'm not going to go through all the. I've given you the ethics ordinance. Again, the key thing, ethics, is the general concept of do what's right. Procedurally, outside of the meeting, in terms of how you make your decisions and what you consider, do what's right. If you have a conflict or anything that looks like a conflict, if you have a question, ask staff, ask me. We will, give you advice on to whether or not it's one that you should recuse or not. But it's not really that difficult. There's state codes, and you've got this in your packet that I gave you. I provide you the whole set of the City of Milton Code of Ethics. But the bottom line is if you have a financial interest in the decision, whether if the direct financial interest in you own the property, direct financial interest, you're adjacent and it's going to affect your property values. If it's going to affect your interest in a business, if you own a competitor of the business that's going in next door or just down the street, it should be obvious. I've got a conflict or I've got an appearance of a conflict, and I don't want to jeopardize the eventual result being challenged based on my conflict, so I'm going to step back and recuse. And that's the general idea. If you have any questions about it, just get in touch with me. I mean, again, act ethically. Don't. Again, whenever the issue comes, if you have any question, there's two things to do. One is if you feel like there's a question, it's probably a chance. If you still think you can act impartially, just to announce, hey, I own property that's in the subdivision, but it's all the way at the other entrance. Where I'm not impacted by this at all. I can act impartially and will render a fair decision without bias. That's fine. I just wanted to put it on the record. Great. That's really all we need. If you feel like you can't, or that it's too strong of a appearance of a conflict, then just announce whatever the factual situation is. Therefore, I'm going to recuse myself. Go step down for that one particular item. Come back as soon as it's done. Any questions about? We've beaten it twice, so I'm assuming we've pretty much covered open meetings, and I've got all of the statutory requirements. The key is if there's a quorum of you, so if there's 4 of you together, there's a potential that someone could see 4 of you together and go, meeting of the Planning Commission, they didn't advertise that, they didn't announce that, they failed to follow the rules, I'm going to make a challenge. Legally, the requirement is that if you meet without complying with the state's open meetings laws, then any decision made therein could be rendered void within a certain period of time. So technically, if you don't do anything, then you haven't, there's nothing, there, you may have violated the ordinance, but there's no remedy because you didn't do anything to cancel. That being said, how does anybody know whether or not you did anything? They may say, well, you were discussing the next upcoming application for the next month's meeting, and you didn't do that in an open meeting. So I'm going to challenge the approval of that application once the mayor and city council approve it. And we're sitting trying to explain, well, I know they were meeting, but here's the affidavit of the 4 members that you saw, and they say they did. Well, we've created a headache and a nightmare, and you have to, sign an affidavit, review and sign an affidavit, or sit down for a deposition. And nobody wants that, so try to avoid being in a situation where a body of 4 of you are together. I mean, together is a question, but at least in a situation which might suggest to someone that there could be business being discussed. Whether or not there is or not. Now, there are exceptions. If you go to training, for instance, that would not be considered. If you're all at the same training session, there's an exception for that. So if anything like that comes up, let us know, and we can say, yeah, go ahead, no problem.
So, Paul, what if, this is an example, it's a Christmas season and there's Christmas parties.
Our
and
official.
Everybody's 4 of you are invited to the same party, but I mean, obviously, yeah.
Again, this boils down to the appearance.
So just don't talk to each other.
If 4 of you are invited independently to someone else's party, probably not a problem at all. And again, I say, what is going to be the harm? Likely nothing. It may be a headache. If you decide to have your own Christmas holiday meeting and all 7 of you meet, just the 7 of you at a restaurant down the street, that may be, that's questionable. We'd recommend that something of that nature not occur, or advertise it. We have done that in the past with the various parties. It's advertised. Yeah, you don't say. I mean, you say no business will be conducted, but when and if that comes up at the end of the year, let us know. But
I was just thinking more, I mean, I do advertise for holiday
I thought-
dinners and all that.
appreciate
I'm
it.
just thinking, a lot of people know the same people and they could be
Yeah.
invited to the same party and then blah,
Well, so
blah,
you,
blah.
you don't have to call every time you get invited to say, did you get invited, or we got, I just want to know if I can go, which four of us are going to, or which three of us get to go, you don't have to, it's more.
That
of a-
actually happened when, hope you won't mind saying it, but when Paul was running for city council, it happened that,
At a fundraiser.
no, we only had three. But,
Okay. And
but it almost is a laughing matter. I hate to use those words, but, you're standing talking and three of us are standing there and all at once, I walk up,
Yeah.
and we have to say, whoop, wait a minute,
Yeah.
get in your truck.
Be conscious of it. In the end, don't freak out and say, I can't be near you. But avoid the clear situation where
Yeah.
there's all seven of you are planning to meet at a particular time.
Right.
If you can not have four of you standing together talking in a huddle, with no one else there, great. If there's a picture of the four planning commission members, in the Herald, then that's better not to have. But again, it's something to be conscious of. It's the bigger meetings that we have more concern about making sure that those don't occur. And the city may have the volunteer appreciation. Y'all are going to be invited. You may come to the volunteer appreciation meeting. Just don't gather together, and certainly don't discuss business. The key is legally, in the end, don't meet and discuss business. And I will say that the next step on that, as we step beyond physical meetings, I would advise you don't discuss business on a full-blown 7-member email chain. If you want to provide comment back to staff, and staff can provide a consensus that it appears that most members are this, that, or the other thing, that will work. But just, with all people throwing in contributions, with all members on the CC chain, that can get to the point where it constitutes conducting business. And if it's not open to the public, then it is arguably potentially in violation of the Open Meetings Act. So try to be conscious of, I don't know how much that is part of your process, but don't discuss business, of the commission over an email conference.
So I think over the years, they've been really good. That really doesn't happen. The only discussions we have are, just
Who's going to be at the meeting?
meeting. Yeah, exactly.
Yeah, that's fine.
Logistical issues. So.
Okay. As you know, and there are procedures in place whereby there has to be a sign, there has to be notice to the neighbors mailed out, there has to be a certain amount of notice in the newspaper advertised, certain amount of, no less than 15 days, no more than 45 days. That stuff staff will take care of. There may be times where, for whatever reason, there is a question as to whether or not the description of the application was correct, whether or not the description of the property was accurately described in the advertisement, whether the sign came down for, 25 of the 30 days, whether the CZIM meeting could occur, whether a public participation meeting, there may be times where things like that come up. There are requirements, procedural requirements that have to take place before the public hearing can be conducted, and there's state rules. There's also the city has adopted additional rules beyond what the state requires. State only requires the sign and the advertisement. The city has added the notice, direct mail notice, and public participation meetings and things of that nature. So there's various ways where the requirements come in. But in order to have a valid public hearing, which the city can rely on as complying with its own statutes and with the state statutes to make their eventual decision legal, means that there may be times where they say, you know what, that didn't happen, it's going to have to come to the next meeting. But know that it's not your responsibility to take care of that. But if staff tells you this hasn't happened, therefore the public hearing would not be legal or effective, then you may have to postpone to the next meeting, and someone will let you know if that's the situation. Let me go through some. This is a procedural thing for the agenda. And I don't remember if this was part of the list of the things on the agenda. When you get as one of your agenda items, I always like to have a adoption or amendment of the agenda at the top of the meeting. So if someone needs, some applicant needs to get out to catch a plane, they ask, for permission to, get moved to the beginning of the meeting, you would say, I move that we amend the agenda to show item 6A or 6F as the first item on the new business, something along those lines. That way you can do it ahead of time rather than when it comes up saying, oh, well, so-and-so said that we need to do that. And rather than doing it informally, have a formal motion to make any changes to the published agenda. Because people, they've seen the agenda online, we've got it over here. If there's any changes, if an item is going to come off of the agenda, that would be an appropriate time, in my opinion. I mean, you don't have to do it that way. You can wait till it comes up and then have a motion to defer. But if an item is going to come off of the agenda for a specific reason, and staff, it has to come off, then it could be done at the top of the meeting is to, make a motion to remove item 6F from the agenda with an explanation of why, of course.
So if we have a contentious item that we know it's going to be a lot of back and forth, we can move it to the bottom so that people aren't sitting here that it doesn't affect them.
That you absolutely could do that. And, it's up to you whether you want to, because you've got 75 people here, do you want to get them out of the hall sooner rather than later, or do you want to not put the 3 or 4 items that have no opposition to get them to go boom, boom, boom and get out? It's up to you. That would be a time to consider whether or not you want to do that. You're welcome to do that. And policy decision amongst yourselves or the city, if they have any.
So, for example, I guess my question is, like tonight, granted they only sat there for 20 minutes or whatever, but can we have moved that deferral up ahead of the action? How far can we move it? They didn't need to sit here and listen to us appoint members and go through the meeting minutes. If we knew they were going to defer, we could have moved them.
You could have.
Right after the pledge, technically, right?
Yes.
Okay.
Usually it would go, open the meeting. Yeah, and I don't recall. I think, let me see the bylaws, if they have a.
The reason why it may have been better to do it this way still was
The
that we have
election
the
of
officers.
But I'm saying, this was next
Something
meeting.
else, yeah, well, we don't have officers in place. I mean, now we have
Yeah.
officers in place, and we do it then.
Yeah, and theoretically, I guess, Simi, were you no, you weren't. Do we have the vice chair was off too? So this was a
Right,
no.
right, so-
So I should have, so that was the right way to do it. Great.
No, I'm just
Yeah,
asking for.
yeah, but yes, typically what you do is you open the meeting, introduce members, stay the pledge, amend or adopt the agenda. And that's where you can make any change. And then you can bring it to the very next item. Or you could do it after approval of the minutes, or the first item of the new business, or,
So, but in terms of moving items on an agenda, can we only do that at the actual meeting, or could we hypothetically do that if Robin sent us the meeting? I mean, here's the agenda, a week in advance, and we're like, oh, that's a big ticket item. Let's move that to the end. Could we do that then, or do we need to do it at?
Well, let me say, you can't do it as a body.
That's true, yeah. I mean,
You can't
maybe
conduct a
the chair
poll and
made
vote.
a suggestion to me and said, by the way,
know,
Robin, why don't you organize it this way?
If staff has enough time to post it according to its requirements, I would say probably if the agenda has been posted, there's no real chance to explain why it was changed.
I just know I've sat on that side before, and I've been like a consent item, and I've sat through like an hour and a half debate, and it's awful.
Yeah,
So
that is.
thinking about those people, if there's just easy stuff. Just
That is something that's done. You can discuss, when you make the motion, you explain that's, like, I understand there's a lot of people that are opposed to this, and it may take a long time. I know there's several others that may be quicker. And the thing is, you never know.
Because then we end up
Yeah.
time and
Yeah. Or you may have one where there's no opposition, but you all are looking at it going, this doesn't make any sense, I should have done this, but you'll know. Anyway, yes, that is justified. That is a reason that you could move them around, and you can do that as soon, it sounds like we may need to come up with maybe a set of bylaws that may have that, a couple of revisions. I think you said
Right. I think we need to work on
the statement,
bylaws,
the statement maybe a lot dated with the date of the meetings and stuff like that. But we can do that. Anyway, absolutely, yes. Let's see. There's, the staff will get out the meeting summaries within 2 days. Minutes. Just for the record, when we asked to clarify who voted for, against, and abstained, there is the sunshine laws, Georgia sunshine laws require that the minutes specifically reflect who voted which way on any item. So when you know who was for and who was against, we can figure, if it's unanimous, we can figure it out based on who was here. If it's, unanimous with 2 abstentions, we just need to make sure that the minutes reflect who abstained so that comply with the law. While there is a provision to call in and individually, unless there's an emergency, you can't conduct a kind of a universal teleconference for the meetings where everybody's calling in on one teleconference. There shouldn't be any emergency that would require this board to do that, I don't think. I'm pretty sure that's never come up. But if you have a need to, please check with us and say, I need to call in, and we make sure that occurs. There may be a limit on the number of times you can do that in a given year, but we'll address that if it ever comes up. I don't think any of these comments. That does it. I am open to any additional questions or totally off-topic questions that you may have. I know I tried to cover everything that might come up and went into some detail. I realize I
I guess
dragged.
at the end of the day, you or somebody from the attorney's office is going to be at all the meetings, right? So if there is a dispute or if there's any question, we can always just look and ask.
I have not officially heard that.
Yeah, so
I
I know you haven't been on the board, but it has been just the last, couple years we've had a city attorney here, and because we had kind of inconsistent meetings, we didn't. So we're still, as of now, I believe the plan is to have a city attorney here. So.
And again,
It's not required by anything.
Right.
Yeah. Right.
And
yeah.
and with all deferral to city staff and the city manager's policies or whatever, I am available to respond to members and any questions you may have. It may be, if it's technical questions, anything about the ordinance, the requirements of the ordinance, stuff like that, I will tell you. Robin and her staff knows much more about the details of what's in there than I do. I've got it, I've got it sitting right there, and I'll bring it to the meetings, but they deal with it every day, and they'll know those. But any question about procedures or, drafting a potential condition or anything that you may want, I'm open, or if you want to go ask staff to find out what the city attorney thinks, feel free to make sure that you're clear on what you want to do.
So I had also sent an email toward the end of the day referencing the Atlanta Regional Commission does a boards and commissions training on 2 days. They're separated by a month. So I think Ron's gone. Sumet, you gone? Have you gone? You have not gone yet. So I think we have enough money in this fiscal year to do 2 people to do it, to be paid for. So, look at the email, look at the dates. It's all day. I did notice the May one was like May 29th, which is not a great time because that's a lot of people start going on vacation. But anyway.
So that differs from the 3-day training that I did last year, correct?
So I think it's very similar to that. So for whatever reason, then they must have shrunk it to 2 days. But so I don't know. Ron and Kurt could tell you about it. Oh, it was great. Oh, it was horrible. It was whatever.
I found valuable. Yeah, it was very
You said there was good lunch.
Yeah, good.
Yeah, good lunch. Yeah.
Danish in the morning.
That's all I'm worried about today.
So anyway,
It was very worthwhile. They put on a very good set of presentations.
and then if you're really interested, so we have, and I think Ron went to the state GPA conference with Parag to Savannah, but in the spring they do a local one that's, I think this year it's all the way in Sandy Springs. So, if that's something, it's usually like a 2-day conference. And if that's something that, hey, you have some time, you want to learn more about planning in general, it's not really necessarily have to do with planning commissioners, but if you enjoy that, then I'll be happy to forward you that information.
Rob, will you forward that to me?
Sure.
I always hear about it, but the day beforehand, or like, oh,
Right.
I'm there.
Yeah.
I'm out of the office for that. And
Yeah.
Never
So
hear
this
about
year
it.
it's in the big metropolis of Sandy Springs. So.
This is the same one, the conference that was up in Athens last year, just in Sandy Springs this year? Where is it?
I don't know where. Maybe they just usually try to make the spring conference a shorter one and more convenient. Usually it's somewhere on the northern side of the state. So I don't know. I can't remember if last spring. It could have been in Athens. So.
One of the things they recommend in the training is that once a year you should go to somebody else's planning commission. Out in Hot Springs, go and just participate, hear what they have to do, see how they do. It's an eye-opening experience. So
Right.
I'd recommend
I mean,
it.
you could just go down the
I've been to
street
the
to
one-
Roswell or
one in
Alpharetta. You don't even,
Alpharetta.
yeah.
Alpharetta.
Yeah.
So it's kind of a funny thing. I'm going to be on your side of the dais tomorrow night in Alpharetta because they have a code enforcement board. So they don't have their code enforcement violations go to municipal court. They have an actual board that makes the decision. So I'm on that board. It's been a tradition, it seems like. Chris Lagerbloom was on it, and then when he moved, then Jim Craig went on it, and then now I'm on it. So I get to be on your side tomorrow night. Actually, tomorrow afternoon. It starts at 3:30. So anyway.
Paul, I'd like to say, I've been sitting here for quite a few years, and fortunately, in those years, we've been following these pretty close. There's a few that I haven't, but I really, really appreciate the time that you have spent bringing not only our new members, but bringing the old one up, too.
So I agree, a lot of value in this. Thank you.
Very good, and we want to see you succeed in it. I mean, hey, we don't want to do anything down the line where we're having to defend a process that could easily have been followed. It probably doesn't affect anything down the line except someone is just going to. It's always there's someone there that may just go, well, that didn't happen right, so therefore it's invalid completely. And like, no, not really. But we have to defend it, and we've got no desire to do that any more than you want to be a part of it. So, hell, hey, good luck. And as I said, any questions, we're happy to make sure you're able to go forward.
So I guess with that, we need a motion to adjourn.
May I hear a motion?
I'll make a motion to adjourn.
Is there a second?
Second.
Okay, great.
All those in favor, please raise your hands.
Yeah,
It's
okay.
unanimous.
Yeah, I think unanimous.